And thank you to the American Constitution Society for inviting me here today to speak on a topic that is crucial to our country and to our traditions of rule of law, keeping faith with our Constitution. I applaud your commitment to our Constitution and to its promises to all Americans to establish justice and to secure the blessings of liberty. But troubling undercurrents remain. These suggest that Judge Sotomayor's life experience is somehow unhelpful to the judgment she would bring to the Supreme Court, or that nominees are activists because they have, to quote President Obama, empathy. This merits a response, I believe, because it is harsh, narrow-minded, and ahistoric to contend that a rich life experience and natural empathy are at odds with the wise exercise of judicial discretion that is the long-standing tradition underlying the American system of law. First, as we all know, discretion is at the heart of the judicial role at all levels of the court system. I hardly need to remind a room full of lawyers that the common law traditions of the Anglo-American system stand on the exercise of judicial discretion, accumulated over generations of individual exercises of judgment and common sense and discretion, focused over time through due deference to precedent. It is the architecture of judge-made law we live with to this day. As a result of this heritage, our legal system bears the imprint of the experience and wisdom and judgment of generations of judges. As Justice Holmes famously explained, the life of the law has not been logic. It has been experience, the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men. You get an idea of the date of the quote from that particular locution. Have had a great deal more to do than the syllogism in determining the rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. This does not mean that judges are without bounds, but there exists a broad and lively discretion that falls short of judicial activism. Benjamin Cardozo, another luminary of American legal theory, put it this way: the judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant, roaming at will in pursuit of his own ideal of beauty or of goodness. He is to draw his inspiration from consecrated principles. He's not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is to exercise a discretion, informed by tradition, methodized by analogy, disciplined by system, and subordinated to the primordial necessity of order in the social life. Wide enough in all conscience is the field of discretion that remains. Within this field of discretion, judges do not, cannot, and should not close their minds to their experience of the world, nor to what that experience teaches them about the effects of their decisions in the outer world. This aspect of our rule of law is an asset for Americans. As Justice John Paul Stevens has explained, the work of federal judges from the days of John Marshall to the present, like the work of the English common law judges, sometimes requires the exercise of judgment, a faculty that inevitably calls into play notions of justice, fairness, and concern about the future impact of a decision. The fact that such concerns play a role in the decisional process does not undermine the legitimacy of the process that for the most part has served the nation well for 2 centuries. Right-wing critics of the administration have latched on to President Obama's description of good judgment as empathy. Even the ranking member of the Judiciary Committee, Senator Sessions, recently suggested that President Obama's use of the word empathy indicates a belief, and I quote him, that a judge should use his or her personal feelings about a particular group or issue to decide a case. I respectfully suggest that that is a bit of a stretch. The president looked for in his nominee and found in Judge Sotomayor the life experience necessary to understand how a court's legal determinations affect the everyday lives of everyday people. Do critics of Judge Sotomayor's nomination really object to this principle? Should we not prefer a nominee who has common sense, who can appreciate how American laws affect different citizens, and who can empathize with the various parties who come before the court, rich or poor, strong or weak? If reaching correct outcomes were as simple as plugging a few factors and elements into a computer, we wouldn't need 9 Supreme Court justices. Appellate court judges sit in panels of 3 or 4 or 5 or 7 or 9 as a reflection of the fact that a broad range of perspectives and experiences makes for better judgment. As Judge Sotomayor correctly explains, judges must not deny the differences resulting from experience and heritage, but should attempt, as the Supreme Court suggests, continuously to judge when those opinions, sympathies, and prejudices are appropriate. Not that they're never appropriate, but it's a matter of judgment when. Compare that rich and candid consideration of the interaction between experience and judicial judgment with the facile analogy favored by the Republicans that judges are umpires who do no more than call balls and strikes. Of course, that analogy is mistaken. First, lest we forget, Republican nominees themselves recognize that a broad life experience makes for better justice. Less than 4 years ago, Sam Alito, then a judge on the Third Circuit, explained that his personal background and experience enriched his judgment in legal cases. He said this: when a case comes before me involving, let's say, someone who's an immigrant, and we get an awful lot of immigration cases and naturalization cases, I can't help but think of my own ancestors, because it wasn't that long ago when they were in that position. And so it's my job to apply the law. It's not my job to change the law or to bend the law to achieve any result, but when I look at those cases, I have to say to myself, and I do say to myself, you know, this could be your grandfather. This could be your grandmother. They were not citizens at one time, and they were people who came to this country.